Hello, and welcome back to Coin Lady channel, where a court has just issued a brand new document in the SEC versus Ripple case, mandating a settlement conference between the parties, but only if they think it will be fruitful. Additionally, Gary Gensler emerging from his underground bunker. After several days of silence following the shocking, nearly unanimous defeat suffered by the SEC in this regard, the conference's leadership has finally spoken out. And his statements are being interpreted by some as proof that the SEC will file an appeal on this matter. It's possible, but we could be jumping the gun a bit if we think that way. This is a topic I'd want to explore. But before we go any further, let it not be misunderstood that I do not come from a financial or legal background. I am not qualified to give you financial or legal counsel. And remember, you should never use anything I say as a reason to buy or sell something. I'm merely a hobbyist who finds fun in discussing cryptography in the form of YouTube videos. However, just in the recreational sense. This is the very first court document submitted in the case of SEC versus Ripple. Judge Annalisa Torres's signature can be found at the bottom right corner. And there's only this one tiny box that's been ticked. The Honorable Sarah Netburn is hereby referred to in the above captioned action for the following reasons. General pretrial matters such as scheduling, discovery, and non-dispositive pretrial motions and settlements are now checked off. And then there's this other box, which indicates that this is a settlement and no more. Finally, the settlement. Those of you with legal training probably already know that settlement is possible after a major finding following summary judgment, but I didn't know it before. In reality, all I do is play one on YouTube. But I didn't know that settlements after a loss are possible, even if you're a defendant in the remedies phase of the case, and that this has been the situation for the better part of the last 2.5 years. Don't lose sight of the settlement box being processed here. The verdict was devastating for the SEC in every way possible. Because the most important thing, and the second most important thing, isn't even close to batteries. The same amount as the first item. The primary issue is whether or not XRP itself constitutes a security. The SEC's loss was catastrophic. However, it's quite acceptable to adopt a purely technical stance while discussing this matter. Even if it's a split decision, I've already gone over the specifics of what didn't go Ripple's way and why it doesn't matter. I know this isn't why you're retiring, but I thought you should know. That's why talks about a compromise are even possible. But what does this all entail in your opinion? There's a boom in the form of a tweet about a boom. Jack the Ripper Irata wrote this one. Magistrate Judge Netburn settlement expected soon #XRP the standard after referral from Judge Torres? Actually, that's not what I meant at all. This is not a boom, however many O's you add. The identical order was entered 2 years ago. It is now altered to authorize the magistrate to consider pre-trial, scheduling and potential settlement, as explained by attorney Mark Fagel in his response to him. This does not imply that a formal agreement is being negotiated. People might read this and wonder, oh, man, does this mean that there are actually settlement discussions taking place right now? And I get that. Neither I nor the vast majority of you listening would have any kind of background in this, so it's understandable that we would misinterpret what the paperwork means. For this reason, the explanation provided by a former SEC attorney is much appreciated. And there was also this, so there's even more. Annalisa Torres, the judge who issued that order, reportedly said, "Hey, Judge Snapper, and go do that." That was thanks to Judge Netburn. So, consider this. Full screen mode will be activated for the documents below. Fox Business journalist who was on a roll at the time shared it. And she said new Judge Sarah Netburn orders both Ripple and the SEC to agree on 3 mutually convenient dates to schedule a settlement conference, quote, if they believe it to be productive at this time, end quote. Also recommends scheduling 6 to 8 weeks in advance due to the court's busy schedule. So, absolutely, it was requested that this be done. It's that neatly organized, you can see it on the screen. However, some wiggle room exists. Her isn't a given, which is why she reiterated in her post that the SEC and Ripple should move on with the settlement conference if they think it will be fruitful. I feel that a lot of folks who heard this news missed that. You need to study the papers. Yes, it has been ordered, but there is an if in there, so it may not actually occur. Still, I can't help but wonder if being liberal would make me the major winner if I were a Ripple, mean. Certainly not each and every one. Okay, that's okay. Why bother trying to persuade us with something we already know you're not going to do? Would you be willing to settle even now? I guess I'm simply not seeing the value in interfering at this point. Why not let the rest of things play out? Charles Gasborough subsequently forwarded that tweet from Wait, if Ripple won, why is the corporation settling? Eleanor Cheriton wrote. Well, again, this is a misunderstanding, as it does not mean that Ripple the company is settling, as I cited. Rather, it simply means that you are ordered at that point, if that is true, to set up a settlement conference if the parties are thinking that it makes sense for them and be productive at this time. And, once again, even though Ripple, as I said, had the biggest conceivable win out of this case, that doesn't mean there weren't small, mainly unimportant things that Ripple lost. And even if they have to pay a hefty charge, say hundreds of millions of dollars, it will be little compared to what they've already accomplished. For them, financial concerns are irrelevant. Because of this, it is not unfair to describe this as a surprising setback for the SEC and a big one for Ripple, despite the fact that the decision was rendered along party lines. Then you can say something like, okay, what tiny things that Ripple Net get, which they had hoped with gone through, that's fine. However, let's face facts. This was a huge win for XRP investors and a major loss for the SEC. In keeping with what I've been saying, Eleanor Turda added some additional clarity by noting, to be clear, Judge Knepper is suggesting that both sides agree on some possible dates for a settlement meeting, if they believe it's productive at this time. The court's busy schedule means that every settlement date must be planned at least 6 to 8 weeks in advance, thus that timeline does not guarantee a resolution within 16 weeks. Okay, I think I got it. Gary Genshaw, on the other hand. Indeed, that is the case. Kim Jong-un has some strong words about the SEC versus Ripple case. I went ahead and transcribed his remarks for your convenience. And here's a video of them that I'll show you. Eleanor Tarek disseminated it. Clip's length, 32 seconds. There were also numerous oohs and ahs, which I simply edited out. But it looks like I'm reading a transcript of this right now. And, it's only a few of lines. It took them 32 seconds to spit out what amounts to a couple lines at most. I'm telling you, he doesn't seem to know what to do, and that's probably why he's been keeping a low profile on this issue ever since the verdict was handed down a few days ago. But, in any case, here it is, breaking several hours ago, from Eleanor Turret. This is Gary Gensler's first public comment on the Ripple summary judgment finding, which came down a week ago. And here's the quotation. I wonder how long it'll take me to read it. We can rule out 32 seconds. We welcome the court's forward momentum on the issue of fair notice and are heartened by the decision's recognition of the significance of protecting investors, particularly institutional investors. We were disappointed by their assessment of retail investors, but we are still reviewing the report. That settles it, then. About 16 seconds is about how long it takes me to do it. So, 16 of those 32 seconds were just The same thing happened, remember that. I wasn't attempting a speed read. I recently discovered that it takes me 16 seconds to go my usual distance. Not like I was trying to speed read or anything. Time, 16. He spent 32 of them on it. Poor tiny Kimmy is simply a camera and a young dancer. What a fantastic time we had. To be alive now is a great fortune. What he said there is a pretty good signal that we're not done here yet. But that's because the story isn't finished yet. Just take it at face value, maybe. And other local solicitors are hoping against hope that there will be appeals. Who knows? We're going to want to get to some items from attorney Jeremy Hogan, so I'll be talking more about that in an upcoming video. In contrast, attorney John Deaton also said this. According to him, around 2,900 Coinbase users have signed up to act as AMH. For the benefit of those who may have missed it, let us pause to point out that John DT is, in case you hadn't heard, repeating his actions from the SEC Ripple case. Which is what the MySci status is all about, so you can opt to have him represent the case, and he will seek to be a friend of the court again. They had their own interests in mind, as they should have, but not the broader interests of XRP holders, and this is abundantly clear in the SSCP Ripple case. John Deaton played a key role in this regard. Therefore, he is attempting the same thing with the Coinbase here. A judge ruled on a dispute involving two retail investors in XRP, and Gary Gunn's owner Eleanor Turret tweeted about the ruling. Case. You may recall that the Ginsters SEC had an objection to the XRP holder acting as amicus curiae. A little time later, he tweeted, "Consider joining if you don't want Gensler and the SEC lawyer speaking on your behalf," and now here we are at 3,135. The public has grown weary of SEC-style safeguards. Wow, that's incredible. It didn't take long at all. If you were able to get another 235 in how long of a time frame? That was therefore set as the maximum allowed character count, 140. Good, then. Thus, within the space of less than 2 hours, another 235 people registered. Totally cool. Wow, that's incredible. Similarly to the SEC versus Ripple case, you can opt out of having either Coinbase or the SEC represent you in court by speaking on your behalf. In my opinion, it's excellent. John Deaton is spending his own money on all of his charitable endeavors. You should know that he is not being paid for this. Just doing it, that's all. It's not a good choice monetarily, but you can't help but admire his tenacity and determination. Absolutely. Large implications for the future in the SEC versus Ripple case. In the event of a coin toss. Since I'm not a certified financial planner, you shouldn't use my advice to make any investments or trades. Please like and subscribe my channel. See you in the next video, bye.